Hello class, this is chapter 3, the Criminal Act, the first principle of criminal liability. The learning objectives we're going to cover in this chapter are as follows. To know the elements of criminal liability and understand why the voluntary act is the first principle of criminal liability. To know and understand the purposes for Actus Reus requirement. To understand the voluntary act requirement of Actus Reus and appreciate its application to conduct in cases of automatism. We will also identify circumstances when and be able to explain why status is sometimes treated as an affirmative action. We will also discuss that omissions can satisfy the Actus Reus requirement and understand the circumstances when omissions are treated as criminal acts, and understand why possession is treated as an act and know the different types of possession recognized by law. Now we're going to discuss the elements of criminal liability. There are elements of a crime. First, the criminal act, which is an Actus Reus, the requirement that all crimes have to include a criminal act, the physical element, and the first principle of criminal liability. Then there is criminal intent, which is mens rea. This is the mental element in a crime. And concurrence means actual circumstances, not an act, intention, or a bad result. It's a circumstance connected to an act as intent and or a bad result, and the bad result causing criminal harm. Then there's criminal act versus criminal conduct. A criminal act is voluntary body movement versus criminal conduct, which is criminal act triggered by mens rea. Bad result crimes are crimes that include all 5 elements: a voluntary act, the mental element, the circumstantial elements, causation, and criminal harm. Here you can see the flow chart of the elements of criminal conduct crimes. You have Actus Reus, which is voluntary act, plus mens rea, which is general intent, plus mentis rea, which is level of culpability, where someone purposely or knowingly or recklessly or negligently committed a crime, plus the circumstances involved, which are not required but usually included, and those total to equal criminal conduct. Here you see a flow chart of the elements of bad result crimes. You have Actus Rea, which is voluntary act, plus mens rea, which is general intent, plus mentis rea, which are mental levels of culpability, which is purposely, knowingly, recklessly, or negligently committing a crime, plus circumstance, if any, plus causation, which is factual cause and legal cause, which equal a criminal result, the result defined by criminal law as criminal harm. We're going to talk now about the criminal act, or Actus Rea. We punish people for what they do, not for who they are. Imagine a statute that makes it a crime merely to intend to kill another person. Why does such a statute strike us as absurd? First, it's impossible to prove a mental attitude by itself. Second, it's a mental attitude by itself doesn't hurt anybody. A third problem with punishing a state of mind is that it's terribly hard to separate daydreaming from fantasy from intent. We don't punish thoughts because it's impractical, inequitable, and unjust. However, there is manifest criminality, the requirement that mental attitudes have to turn into deeds. Manifest criminality leaves no doubt about the criminal nature of the act. This is the purpose of the Actus Reus requirement. First, acts help to improve intent. We can't see states of mind, we can only infer them from actions. Second, it reserves the harsh sanction of the criminal law for cases of actual danger. Third, it protects the privacy of individuals. The law doesn't have to pry into the thoughts of individuals unless the thinker crosses the, quote, threshold of manifest criminality, end quote. Now we're going to talk about the voluntary act requirement. There are 4 logical steps. First, criminal law punishes people. Second, we can only punish people we can blame. Third, we can only blame people who are responsible for their acts. And fourth, people are responsible only for their voluntary acts. One voluntary act is enough rule exists, which means that conduct that includes a voluntary act satisfies the voluntary act requirement. Then there's automatism, which is unconscious bodily movement. There are fault-based defenses, which are defenses based on creating a reasonable doubt about the prosecution's proof of a voluntary act. And affirmative defenses, which are defenses that take place after the prosecution has proved the defendant's criminal conduct, namely excuses for criminal liability. There are a couple of examples: sleep driving, which is the State versus Newman in 2013, sleep sex, which is called Ludica, epileptic seizures, which was discussed in People versus Levy in 2011. Then there's status, actus reus, and the Constitution, which we're going to talk about next. Now let's talk about the status, actus reus, and the Constitution. Status can arise in two ways: voluntary acts, which are things like addiction or alcoholism, and it can also include characteristics like sex, age, sexual orientation, race, and ethnicity. Is actus reus a constitutional command? In Robinson versus California in 1962, there was a ban on status crimes. The decision that legislatures can't make status or personal condition by itself a crime brought into question the constitutionality of many old status crimes, such as being a prostitute, a drunkard, or a disorderly person. But do these statutes include the requirement of some act in addition to the condition? In Powell versus Texas in 1968, the Constitution bans only pure status as a basis for criminal liability. Real cases in real courts since Powell haven't tried to bring the Constitution further into the principles of criminal liability than Robinson brought in 1962. It's been left in the hands of legislatures to adopt general principles of liability and elements of specific crimes in criminal codes, and it's left in the hands of courts to interpret and apply the code's provisions in decisions involving individual defendants. Now let's talk about omissions as criminal acts. Omissions can satisfy the actus reus requirement and understand the circumstances when omissions are treated as criminal acts. Criminal omission means that it applies only when there is a legal duty to act, a failure to report, like failure to report a crime, failure to intervene when duty calls. Legal duties are created in three ways: through statutes, contracts, and special relationships. There are two approaches to defining a legal duty: to rescue strangers or call for help. Here's a discussion activity for you. Omission is a criminal act only when there is a legal duty to act. Identify some examples where they felt an omission was reasonable on the part of the person who failed to act or report. Tie this into the explanation as to why a legal duty to act is required. Think about things like EMTs in uniform, police in uniform, etc. When it comes to criminal omission, Americans are protected by a Good Samaritan doctrine. This imposes a legal duty to help or call for imperiled strangers, but only a few jurisdictions follow the Good Samaritan approach. The American bystander rule states that there's no legal duty to rescue or summon help for someone who's in danger, even if the bystander risks nothing by helping. Restricting criminal omissions to the failure to perform legal duties is based on three assumptions. First, individual conscience, peer pressure, and other informal mechanisms condemn and prevent behavior more effectively than criminal prosecution. Second, prosecuting omissions puts too heavy of a burden on an already overburdened criminal justice system. Third, criminal law can't force Good Samaritans to help people in need. Here's an activity for you. Do you support the Good Samaritan doctrine or the American bystander rule? What is your reasoning? And what are the negatives and positives of each? Now we're going to talk about possession as a criminal act. We're going to talk about why possession is treated as an act and know the different types of possession recognized by law. There's a legal fiction, which is pretending something that's a fact when it's not, if there's a quote unquote good reason for the pretense. This applies to common criminal possession statutes. The most common of the many criminal possession crimes includes possession of weapons, illegal drugs, and drug paraphernalia. The good reason for pretending possession is an act of the powerful pull of the idea that an ounce of prevention is worth a pound of cure. Better to nip the bud of possession before it grows into an act of doing drugs or shooting someone. Then there's actual possession, which is physical control of banned items on any person. Constructive possession, which are banned items not on any person, but in places that are found that could be controlled. Knowing possession, which are items possessors are aware of that are either in their person or in places they control. And mere possession, which are items you possess, but you don't know what they are. Here's the discussion activity for you. Two of the most common types of criminal possession are illegal drug possession and illegal possession of firearms. Why is it illegal to possess these two items? Should illegal drugs be legal, including marijuana? And should possession of firearms be illegal for certain people or for certain types of firearms? Just as a reminder, there are different types of possession. There's actual possession, which is physical control of a banned item on any person. Constructive possession, which is a banned item not on my person but in place that I can control. Knowing possession, which are items possessors are aware of that are either on their person or in places that they can control. Mere possession, which are items you possess but you don't know what they are. All but 2 states, North Dakota and Washington, require knowing possession. Also, almost all the cases in court reports are constructive possession cases, and they're almost all drugs and or weapons cases. Here's another discussion activity for you. How does the crime of possession play a part in the war on terror? Next question. What potential issues may there be with determining what is an illegal possession as it relates to terrorism? Here are some key cases that you need to read about that relate to everything we talked about in this chapter. The first is State versus Burrell in 1992, where the New Hampshire Supreme Court had to decide whether Mark Burrell's last act before the shooting death had to be voluntary. The next is State versus Newman in Oregon in 2013, where James Robert Newman was convicted in the Circuit Court, Multnomah County, of felony driving under the influence of intoxicants, DUI, and he appealed. The next case is People versus Levy in 2011. Ford J. Levy was convicted in the Justice Court of the town of North Castle of reckless endangerment in the second degree, reckless driving, and speeding. The next case you need to read about is Commonwealth versus Petzisinkas, which is 1992, where the Pennsylvania Superior Court upheld a conviction for failure to act based on a legal duty to act. And then Williams versus the state, which is Florida in 2013, where Zamora Janice Williams was convicted in a jury trial in Circuit Court, Hillsborough County, of possession of cannabis with intent to sell, manufacture, or deliver. Class, as always, thank you for your time. Do consult your instructor if you have any questions about anything that we covered in this chapter. Again, thank you for your time, and we'll see you for Chapter 4.